Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases, laws, and topics affecting New York City residential tenants. I am Michelle Itkowitz, and today we are discussing a relatively new law that allows the representative of a deceased tenant to terminate the tenant's lease and save the estate money. As always, let's first set the stage with some context. Upon the death of a residential tenant in New York State, the lease does not terminate. Just because a tenant dies doesn't mean the lease dies with them. The lease continues. Instead, the tenant's estate becomes liable for the rent for the duration of the lease term. So let's do an example. Let us say, God forbid, your mother passes away and she's renting an apartment in Manhattan and her rent is $6,000 per month. And at the time of her death, she has 9 months left on the lease. That would mean that her empty apartment could cost her estate and your inheritance $54,000, 9 months multiplied by $6,000 per month. The family dealing with the estate might not want to spend $54,000 on an apartment that no one is in. So up until February 2024, the family or other representatives of the deceased didn't have much choice unless they could make a deal with the landlord to be released early from the lease. In February 2024, the New York State Legislature passed Real Property Law Section 236A, A as in apple, and that changes all this. I'm going to put a link to the statute in the show notes. Now, I became aware of this statute because a lawyer who's a friend of mine lost his father recently, and this topic came up, and my friend made me aware of this statute. This slipped by me. I didn't take note of this last February. Here's what the sponsors of this bill in Albany said. They said, quote, "Unless addressed in a residential lease agreement, New York state law does not currently provide the estate of a deceased tenant with the right to terminate the lease upon the death of the tenant. Allowing landlords to hold deceased tenants to their lease terms represents an unreasonable financial burden on the estate." Okay, so now let's see how this statute works. Let's look at the mechanics of it, and let's get into today's new statute. On February 15th, 2024, the New York State Legislature passed a new law, Real Property Law, Section 236A. Again, there'll be a link in the show notes. Now, this is for residential leases in New York State. And the way the statute works, it gives the executor, the administrator, or the legal representative of a deceased tenant the option to immediately terminate the lease upon giving a notice to the landlord. The notice must go by registered or certified mail, return receipt requested, and the notice is effective immediately. And a lease will not be able to eliminate this right. So if they start drafting leases now that say, oh, by the way, Real Property Law Section 236A doesn't apply here, it doesn't matter what they write in the lease to try to get around this. Anything contrary to 236A in the lease is void against public policy. If there's a co-tenant to the lease or a guarantor for the lease, you need to include their written consent to the termination in the notice. Nothing about this statute makes rent arrears from before the termination notice go away. So if, God forbid, your mother passed away and she owed 3 months of rent at the time, those 3 months are still due. This doesn't do anything about the past. This notice just deals with the future. And finally, this new law is not applicable to a deceased co-op shareholder who was holding a proprietary lease in a co-op. So all of this brings up some interesting tenant takeaways, but first let's get the housekeeping out of the way. This is not legal advice and I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. And if you deem this work worthy, please bestow upon us the 5 stars and do us the honor of subscribing. It's time for the tenant takeaway. Tenant takeaway time. I'm afraid in this tenant takeaway time, I'm going to have probably more questions than answers, but that's what we need to do with a new statute. We need to start questioning it. Okay, so Real Property Law 236A says that the notice can be given by an executor or administrator of the estate. Now, I'm not an estate lawyer. I'm a landlord-tenant litigator, but I'm vaguely aware that it can take a while to get an executor or administrator appointed by the court. But notice that the statute says the notice can also be given by a legal representative of the deceased, and I'm just not sure what a legal representative is. So if you're working with a lawyer for your deceased relative's estate, show them this statute and they'll probably handle all of this part of it for you. Where though I see it being a little bit tricky is that you're always going to want to coordinate this surrender notice with cleaning out the deceased's personal property from the apartment. I mean, you obviously can't surrender until you've dealt with the personal property, because after you surrender, you can't get back into the apartment. I'm just curious how this would work if you were trying to get a moving truck to empty out an apartment via a legal representative as opposed to a properly appointed executor or administrator. The thing is, many landlords are hesitant to give anybody access to the apartment until they have letters testamentary, which is what an executor would have, or letters of administration, which is what an administrator would have. Because, let's say child number 1 shows up and cleans out the apartment, and then a week later, child number 2 shows up and says, "Landlord, why did you give all my mother's diamond rings to my sister?" Something like that. The point is, landlords don't want to get into the middle of it, so they wait for official documents from a court saying who's in charge of this person's estate, and that's who gets in. So I don't know how the legal representative part fits in with all of that. So talk to your estate lawyer, but at least now we know the law is there. And it seems like a very compassionate law. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.